Ladies and gentlemen, you don't have to speak Dutch, I hope, to understand that this is a very long sentence. Am I right? I still find them sometimes in decisions of our court, but the good news is those sentences become more and more rare. That was quite different when I started at the court some 20 years ago. 20 years ago, the Dutch judiciary slowly, carefully started to professionalize the communication of courts, and the 4 biggest courts appointed communication professionals, and I was one of them. And when I pointed out to judges that their decisions were not always that easy to read, they looked at me like, "Why are you bothered? Why do you care?" And others told me not to meddle with their affairs, because they said, how I write my judgment, it's up to me because I'm an independent judge. So at that time, courts had a more or less inside focus. A lot of judges were sending their messages in their decisions and didn't care at all about the receiver. And there was no need, because the authority in the outside world was self-evident. The very old communication theory of the hypodermic needle, you stick a needle in someone and you inject, and the receiver receives it as you inject it, that was leading. But we persisted. We opened the windows, and the time was ripe. And I think the time was ripe because the public interest in the work of courts increased, and particularly in criminal cases. That probably started with a groundbreaking case where 2 men who had been convicted of murder and served their time, they were acquitted after a retrial. And of course, the public didn't understand how such a miscarriage of justice could happen. So that was at that time. And of course, it became more and more easy to express your opinion via social media. So, the public trust in the judiciary was not that self-evident anymore. And slowly the awareness sank in that we had to open the windows, not taking the trust for granted. So we started to invest in professional public relations and media relations, and we developed a national communication strategy for the judiciary, drawn by the heads of communications together and approved by all the presidents of the courts and the chairman for the Council of the Judiciary. The strategy, the communication strategy, is based on the national agenda of the judiciary and on research on the reputation of the Dutch judiciary. Our communication challenge was to enhance public trust in a turbulent climate by increasing transparency while preserving our core values. So we determined 2 main goals. Images and expectations about the judiciary are consistent with the way justice is done. And the other one is more internally focused. Every employee is proud to be part of the judiciary and feels responsible for the public image of the judiciary. And from the main goals, for example, that one, we deduced goals and actions for internal and external affairs. For example, from that main goal, we deduced the goal, the judiciary communicates proactively in cases of social importance. Well, what kind of action can you make? We pronounce judgments orally, and we make a summary in clear language to read out loud. So that was that on a national level. But besides the national goals, our own court made a own multi-annual communication plan, because the level of internal and external communication in every court in Holland differs. And the board of courts have their own priorities. And in our court, the priority was to stimulate the accessibility of our court. And so per target group, I described what do we want in that field, where do we stand now, what developments are foreseen, so what do we have to do in the next 5 years. So I developed a lot of extra activities for the target groups. For example, educational programs for students, presentation courses for judges, and a project also to examine the correspondence of our court. And we examined all the correspondence, all the letters we sent to the people in ordinary civil cases. And we didn't just look at the words and sentences, but we also started to ask ourselves, is it really necessary to send this letter with this content on this moment to these people? And a lot of times the answer was no. And we were also a bit embarrassed because sometimes we couldn't understand the letter ourselves as well. We didn't think what we were communicating. So it was quite a project to adjust all the letters. And also because the judicial process can be very difficult. It was a difficult process. And it's also very difficult to answer the question, how do we preserve the clear language in those letters when you're done editing them? So in any case, what we learned was that it's very important to actively involve judges and clerks and not to turn it into a party for communication professionals. That's what we learned. But our main projects, decisions. And if people don't understand what we say, we're not accessible. So as an extra activity, we thought in our court it would be a very good idea to focus on our decisions. That's why I developed a training for judges and clerks to enhance the use of clear language in decisions. Is the situation that bad in Holland? Well, but a famous judgment shows that there is some work to be done. In that case, judges of the highest instance ruled that a so-called rush hour lane on a highway could be used. But a few years later, one of the judges drove on that same highway and he didn't understand why that lane was closed. Well, to cut a long story short, it turned out that no one had understood the decision of the court. Not the lawyers, not the politicians, not even the state attorney or the minister. They were all under the impression that the use of that lane was prohibited. So that cost a lot of money. People were angry about it. But back to the training. Before we even speak about the language judges are using, we always pay attention to the communication context of texts. So, let me ask you the same question. As judges, for whom are you writing? For the parties. For the appeal court. That's what I always hear, appeal court. For the lawyers. Do you have anyone in mind when you start to write? I want you to meet Min. Min, we always say, this is Min from Assen. That's a small provincial town. And if you don't have anyone you can think of, picture Mien. Mien has to understand what you're writing. So, Mien. Do you think in advance, what does your reader want to know? What is your goal? Do you think about this before writing? Before starting to write? What is your message? Is your message the decision or the motivation? Why you reached that decision? And it's all important because it has consequences for the way you're structuring your text. What layout do you choose? Because if you know what you want to tell to whom and why, then it's time to choose a layout. Do you use an introduction? Do you present the facts? Do you use subheadings? I don't know how it is in your countries, but I think in Holland a lot of decisions are very long. So I always like it when judges make use of good subheadings. And by the way, long doesn't necessarily mean clear. If you want to use clear language, it could be that your decision gets longer. It's not necessarily shorter. And do you start, I always wonder, do you start with the operative part? Do you start with the decision, okay, 10 years for you, and then explain? Or do you start explaining and then build up suspense? Do you have to, can you choose it yourself, or is there is there a structure you have to use? You have to use it. Oh. No. Judges of a special court in a special appeal court in Holland agreed on the structure of their decisions, and they incorporated what I just told. There's an introduction. They all use an introduction. They all use subheadings, and they also agreed on not to cite articles in the text, articles of law, but use an annex for that. And they don't use jargon. Then we always think about, are you a thinker or a doer? If you're a thinker, you think before you write. So you overthink your argumentation, while doers start to write and build up their argumentation when writing. I think a lot of people have both, but a thinker has more time to pay attention to how he writes, what words he uses. So I think that's an advantage. And in the training, of course, we pay a lot of attention to the text of decisions. I always study the judgments of the judges who participate and use those judgments to hold up a mirror. So long sentences, the use of passive tense, a lot of legal terminology, old-fashioned words. I hold up the mirror. And from their judgments, I deduce hints and tips for them, like give your sentences rhythm. So don't use long sentences, but also avoid the use of very short ones. So you have to keep a balance, because that's better to read. Keep the subject, the verb, and the object together in a sentence. Use an active style and not a passive style. Avoid jargon, of course, and avoid the use of articles of law in the text. And And after the session, everyone gets this frame to put on the desk with all the hints and tips for their things. And we always end our trainings with the mumbo jumbo bingo. The mumbo jumbo bingo card we fill in together. Everyone gets to shout words they agreed on never, never, ever, ever, ever to use again. We put it on the mumbo jumbo bingo card. And when a judge does use one of these words, he gets a cross. And when the bingo card is full, well, you know, that's just for fun. Because, that's very important, clear language is fun. Lineke?